Why personal planning documents matter in British Columbia. Have you ever asked yourself, what happens to my family if something happens to me? You might think that you are too young, or not wealthy enough, or that your loved ones will figure it out. But the truth is, without the right legal documents in place, the law, not you, will make those decisions. My name is Nik Eskin, and I'm a Notary Public in Vancouver, British Columbia. I have been helping people like you with real estate transactions and personal planning documents since 2012. Today, I want to explain the 3 core legal documents that every adult in British Columbia should consider having, no matter their age, assets, or family situation. These documents aren't just paperwork. They are protection. They speak for you when you cannot. Let's begin with the will. In British Columbia, over half of the residents still do not have a will. When somebody dies without a will, it is called dying intestate. That means that the government, under the Wills, Estates and Succession Act, or WESA, will decide how your estate is divided. Many assume that their spouse would simply inherit everything automatically. That is a misconception. In British Columbia, if you die without a will and leave behind a spouse and children, your estate is split between the spouse and all the children, even if the children are from a previous relationship. And if you are separated but not legally divorced, your ex might still be entitled to part of your estate. That's not something most people want. A will ensures that you choose who inherits your assets. You appoint someone you trust to carry out your wishes, a person known as the executor. You name a guardian for your minor children, and this is really critical. Without a will, the court will decide, and your child will be placed under the care of public guardian and trustee until such a guardian is appointed. In a will, you can also leave gifts to friends, charities, or causes that are close to your heart, none of which will receive anything under WESA unless you state it clearly in your will. And don't forget, wills need to be updated. Life changes if you get married or get divorced. If you gained assets, lost a beneficiary, or bought property, your will should reflect that. Now I'd like to talk about the second most essential document in the personal planning package, called powers of attorney. A power of attorney allows you to appoint another person, your attorney, to make financial decisions on your behalf, even if you become incapacitated or even mentally incapable. The attorney appointed by you can pay your bills, can manage your investments, can sell your property, can file taxes on your behalf, and can access your bank accounts. Without a power of attorney, your loved ones may have to apply to court to manage your affairs. That takes time and adds stress, especially if there is an urgent need, like a home sale or a tax payment. There are different types of powers of attorney. There is a specific power of attorney used for one-time actions like selling a property. There is a general power of attorney used for broader, ongoing tasks. Then there is an enduring power of attorney. It remains valid even after you lose capacity. This is the one most people need for long-term planning. Imagine you are unexpectedly hospitalized and unable to sign closing documents for the sale of your home. Without an enduring power of attorney, the deal might collapse. Representation agreement. Who makes medical decisions for you? The third key document is the representation agreement. This allows someone you trust, to make healthcare and personal care decisions on your behalf if you are no longer capable. There are 2 types of representation agreements. There is a Section 7 standard representation agreement, which covers basic healthcare and routine financial matters. And then there is Section 9, or Enhanced Representation Agreement. It allows your representative to make critical medical decisions, including end-of-life decisions. Without a representation agreement, Your spouse or close family member may be unable to act on your behalf, especially in complex medical situations. The care facility may demand legal proof, or you may be forced into a court process to gain decision-making rights. Preparing ahead means less stress during an acute medical crisis. It means peace of mind knowing that someone you trust is making critical decisions for you. It means avoiding unnecessary legal costs or delays. Representation agreements do not expire. Once signed, they remain in force for as long as needed.